Hello everyone. Today we'll be discussing board and its powers. First of all, we'll be discussing composition of board of directors of a listed company in India. According to section 2 subsection 34 of Companies Act 2013, a director is who is appointed to the board of directors. According to section 2 subsection 10 of the Companies Act 2013, board of directors in the company means the altogether body of the directors of the company. According to section 149 of the Companies Act 2013, the board of directors of each company shall comprise of only individuals. That means body corporates, firms or association shall not be appointed as a director. Now, minimum and maximum number of directors. Section 149 subsection 1 of Companies Act 2013 states minimum and maximum number of directors in a company. The minimum number of directors in private limited company is 2, for public company it is 3 directors, and in one-person company it shall have minimum 1 director. However, maximum number of directors in a company is 15. The company can raise the number of directors beyond 15 by passing a special resolution in the general meeting. Directorship of an individual. The provision of directorship of an individual is specified under section 165 of Companies Act 2013, which is as follows. Number 1, an individual can be a director in 20 companies that includes alternate directorships. Second, an individual cannot be a director in more than 10 public limited companies. Number 3, if the company wants to lessen the number of directorship for directors, the company can do so by passing a special resolution. Number 4, such person shall not act as a director in more than the specified number of companies after dispatching the resignation or the expiry of that act, whichever is earlier. Number 5, if a person is a director of a private company, which is subsidiary or a holding company of a public limited company, then the director will be considered as a director of public limited company. Number 6, the directorship is dormant company or section 8 company will be excluded for calculation of limit of directorship of 20 companies. Number 7, if any director contravenes the provisions of section 165 of Companies Act 2013, then he will be punishable with a fine of rupees 2000 for each day during which such default continues, subject to a maximum of rupees 2 lakh. Number 8, furthermore, directorship is in listed entities. Listed entities shall make sure that no person is a director in more than 8 listed entities with effect from 1st April 2019 and not in more than 8 listed entities with effect from 1st April 2020. However, the director shall not act as independent director in more than 7 listed entities. If a director is a whole-time director or a managing director in any listed entities, he shall serve as an independent director in not more than 3 listed entities. The estimation for the number of listed entities on which a person is a director or independent director shall only be whose equity shares are listed on the stock exchange. Now coming upon the composition of board of directors in a listed company. According to Regulation 17 of Securities Exchange Board of India, Listing Obligations and Disclosure Requirement 2015, the following is the composition of board of directors in a listed company. The board of directors shall have a mixture of executive, non-executive directors with at least one woman director, and not less than 50% of the board of directors shall constitute non-executive director. If the chairperson of the board of directors is a non-executive director, then at least 1/3 of the board of directors shall constitute independent directors. And if the listed entity has an executive chairperson, then at least half of the board of directors shall comprise of independent directors. Now let's discuss the committees under the board of directors. Number 1, Audit Committee, Nomination and Remuneration Committee, Stakeholders Relationship Committee, Risk Management Committee. So talking about number 1, Audit Committee. The Audit Committee should have minimum of 3 members. A total of 2/3 of committee comprises of independent directors. At least one member should have expertise in the field of account and finance, and all the audit members must be well in finance. An independent director will be the chairperson of the audit committee. The company secretary shall be appointed as a secretary. Number 2, Nomination and Remuneration Committee. The committee shall comprise of at least 3 directors. All members must be non-executive directors. At least 50% of the directors shall be non-executive member. Directors of the committee will be an independent director. Third, Stakeholders Relationship Committee. The Stakeholders Relationship Committee takes care of all the issues related to the problems such as grievances of shareholders, debenture holders and other parties of importance. This committee looks into such matters and resolves issue while maintaining a good relationship with shareholders and other parties. Thus, the chairman of this committee has to be a non-executive member director from among the board of directors. So, number 4, Risk Management Committee. The members of the board will form the Risk Management Committee. A major portion of Risk Management Committee shall consist of members of board. The chairman of Risk Management Committee shall be a member of the board. Now, we'll talk about the type of directors. Residential director. According to the regulations mentioned in section 149 subsection 3 of Companies Act 2013, it is mandatory to appoint a director who has stayed in India for not less than 182 days in the last calendar year. Small shareholders director. This type of director exists only in listed companies. Listed company on the notice served by 1000 shareholders or 10% of shareholders, whichever is less, need to appoint a director from these shareholders. Women director. As per section 149 subsection 1 clause A of the Companies Act 2013, every listed company or a company having the following characteristics need to appoint a woman director. The criteria is the paid up capital should be more than 100 crores. The turnover is rupees 300 crores or more. Then a woman director is appointed. Additional director. A proposed director will be appointed as an additional director until the next annual general meeting takes place. This provision is mentioned under section 161, subsection 1 of Companies Act 2013. If the annual general meeting does not take place, then such term would end on the date annual general meeting was supposed to be held. Alternate directors. Alternate directors are appointed if the director is absent from the country for more than 3 months. This appointment procedure is mentioned under section 161, subsection 2 of Companies Act 2013. Shadow director. Any person who is not a part of the board of directors but has some power to run the business operations can be appointed as a shadow director. Nominee director. A nominee director is appointed in case of mismanagement or oppressive conducts from the board of directors. These directors are appointed by either special class of shareholders or financial institution, third party, by contracts or by the government. Independent directors. The following conditions make it mandatory to appoint independent directors in case of a public company as per the Rule 3 of Companies Rule 2014. On the condition, paid up capital should be more than 10 crores rupees and turnover should be more than 100 crore rupees and total outstanding loan deposits and debentures should be more than 50 crore rupees. Now, let's talk about the appointment rights, duties and liabilities of a director in a company. A director is defined by section 2 subsection 13 of Companies Act of 1956 as any person exercising the position of director by whatever name called. Their appointment, duties, retirement rights and salaries are all covered under the Articles of Association. Appointment of a director in a company is made as per the provisions of section 150 to 159 of the Companies Act 2013. Companies Act 2013 prescribes that only a real person can be appointed as a member of board of directors. Directors' appointment is generally done by the shareholders of the company. Appointment of about 2/3 directors in both public and private companies done by shareholders. Rest 1/3 of the member of board of directors are appointed in accordance with the Articles of Association. Article of Association may prescribe the appointment of any or all of the directors in case of private sector company. However, if their article is silent, then only shareholders appoint all of its directors. Permission of appointing 2/3 of directors by the principle of proportional representation is granted to the company by a clause included in the Companies Act. Power to exercise this permission by the company depends on whether it has implemented this policy. Nominee directors are appointed within the company either by government or 2/3 by monitoring the misconduct or mismanagement. Their prime duties are to act honestly and take utmost care while delivering their duties within the company. Managing directors are appointed for a maximum tenure of 5 years and must be necessarily an individual. An individual who has served as a managing director of any previous running company can be reappointed as a managing director in new company with the approval of board of directors of the first company. There are numerous conditions with regard to appointment of director in a company. Number 1, he must possess the director identification number as per section 154 of Companies Act 2013. Second, individual must have an age limit in between 25 to 70 years. This age bar is not applicable in appointment made by central government or through passing of special resolution in general meeting by company. Number 3, individual must be resident of India, which means that he or she has been staying in India for a period not less than 12 months, immediately preceding the date of appointment as managerial personnel. Number 4, he or she has not faced imprisonment for any period and is not detained under the Conservation of Foreign Exchange and Prevention of Smuggling Activities Act 1974. Name of first director to be appointed as listed in Article of Association of Company. In case article does not contain any names, then memorandum subscribers are the first directors. Number 6, directors are established in first general meeting by company's initial members. Number 7, in case of any need arises, additional directors may also be appointed by company. Number 8, if director is absent for a period not less than 3 months, an additional director may be appointed. Number 9, member of board may take up the vacant director position on temporary basis. Now talk about rights and duties of a director in a company. In order to create policies that would yield high results, director must have a vision. To achieve high levels of success, they must set the company's goal. They must be able to conduct the company's objective. Then there is a director's function and responsibilities. Directors have various safeguards in place to protect themselves and the company's interests. Below is the description of right of directors. Directors' individual rights. Number 1, inspection of books of accounts. Number 2, right to receive board meeting notices. Number 3, right to obtain circular resolution draft. Number 4, right to be a sitting fee. Number 5, right to speak in the general meetings. Number 6, inspection of board meetings minutes is a legal right. Number 7, he has the right to record his dissents. Number 8, right to vote and participate in board meetings. Number 9, the ability to claim travel, lodging and other expenditures. Number 10, the right to call board meetings. Number 11, right to request an alternate director from the board of directors. Now talking about the collective rights in the company. Number 1, right to prohibit shares. Number 2, the right to choose a chairman. Number 3, right to nominate a managing director and make dividend recommendations. Number 4, investment approval authority. Talking about the duties of a director in a company, the board of director functions as the company's agent. However, when acting for the company, the director must fulfill the following responsibilities: act in good faith and in accordance with the company's article of association, to act in the best interest of the company and its stakeholders in order to promote the company's act's objective, exercise due and reasonable care when performing obligations, to make independent decisions, not to get engaged in the situation where his interests are at odds with the company's and he is unable to delegate his duties to anyone else, to avoid gaining an unfair advantage or profit. Talking about the director's liability in a company, the director may be held jointly or collectively accountable for any and all conduct detrimental to the company's interest, although the director and the company are separate entities. The director can be held liable on the company's behalf in following circumstances. SEBI can take legal action against director who fail to make the required disclosures under the SEBI Acquisition of Shares and Takeovers Regulation 1997 and SEBI Prohibition of Insider Trading Regulation 1992. Share application cost refunds or excess share application fees to cover the cost of qualification shares, civil liability for misrepresentation in the prospectus, Any present or previous director during the defaulter's time period shall be liable to pay the tax shortfall as well as any penalties unless a director or a former director can establish that the non-recovery or non-payment of taxes due to gross negligence or violation of the duty. If the majority of shareholders participate in fraud on the minority or discriminatory behavior, the directors and the corporations may be held accountable. As a result, this is a precious clause that directors should be aware of and try to exploit as much as possible. A company is required by the Companies Act to acquire insurance to protect itself from losses caused by its director. A director may also obtain insurance to cover damages suffered owing to the company's liability, with the corporation charging the price. To conclude, the board of directors is the heart and soul of the firm and they are crucial to its success because more power comes with more responsibility. Firm management should be in the hands of competent people who know how to utilize their power wisely. A board of directors governs the firm and all of the corporation's decisions are made in an organizational meeting. That's all for today. Thank you.